Welcome to the Not So Legal Show, and the sheen continues as Charlie Sheen has now been fired from 2.5 Men. He seems crazier than ever, and is he really winning? There's so much media attention on this guy. Maybe I should just stop talking about him too. Let's jump into some Not So Legal Show advice. So we all have great ideas, right? But how do you know when an idea is copyrightable? I'll tell you about an idea that isn't. An author of a children's cookbook sued Jerry Seinfeld's wife for claiming she stole her idea to slip vegetables into your children's food because Jessica mentioned that idea in her book, Deceptively Delicious. I didn't realize figuring out how to get your kids to eat vegetables was such a hot topic. Regardless, if it hadn't been Jessica Seinfeld, I doubt this case would have even gotten this far. The Second U.S. Circuit Court of Appeals said in its decision that stockpiling vegetable purees for covert use in children's food is an idea that cannot be copyrighted. Good to know. People always ask, though, do I need to register my copyright? The real purpose of registering your copyright is to protect against copyright infringement. The mere act of registering your copyright isn't the reason why you have the copyright. Technically, your work is protected the moment it is created and fixed in a tangible form. Registering it just makes it easier to prove you have the copyright rather than having to go through emails or old files just to show that the copyright is yours. For those of you dying to learn more, check out copyright.gov as it will give you all the information you need. Now, usually you can't talk about copyright without talking about trademark. What's the difference between a trademark and a copyright? A trademark is a word, phrase, symbol, or design, or some combination of these four things that identifies and distinguishes the sources of the goods of one party from those of the others. If you have a business, one of your biggest assets out there is having a trademark. Usually it's some logo or other mark that represents your business. Now, depending on the type of registration, a trademark in one class will cost you $325. And yes, I would advise you to hire an attorney to file it, only because if you blow it, you have to pay another $325 as the trademark office doesn't just let you fix your mistakes. Again, for those of you dying to learn more, check out uspto.gov for all the trademark information you could want. In other legal news, for those football fans out there, the NFL is still trying to work out their labor deal. The NFL hasn't lost any games due to a work stoppage in nearly 25 years. So why stop now? Money's one of the main issues, along with trying to expand the regular season from 16 to 18 games. I wouldn't mind seeing 18 games, but isn't watching guys bash into each other for 16 games enough? Speaking of games, it's almost time for March Madness. A few not-so-legal fans have written into me to ask if I could keep some tabs on a few teams. University of Florida, UCLA, North Carolina, Duke, San Diego State, Texas, and Brigham Young. You got all that? Let's see what happens these next few weeks. That's it for now. Always remember to honor your power and stay tuned for the next video posting.